that if you are born or if you have come before a particular date, then you are deemed to be a citizen of India. That was when the constitution was framed. Subsequent to the constitution, there may be situations where the nation needs to confer citizenship on various other grounds, or take away somebody's citizenship on certain grounds, and therefore Article 11. 6 and 7 are deemed citizenship when constitution came. 11 is for future contingencies. Second, and this is on textual reading only. If 6 and 7 were to be frozen in time, as argued by the petitioner, then why have 11 at all? Then 6 and 7 is complete code. There cannot be any additional reasons for conferment of citizenship, or there is no provision for taking away citizenship.
To which their answer would be that Article 6 and 7 is Pakistan specific. That it basically deals only with Pakistan, right?
Correct, Manoj.
So the purpose of 11 is broader. 11 covers, but it will, Article 11 would not cover only Pakistan. It will cover the entirety of the
world. Well, there may be several citizens. For example, Malod,
the argument was that once, which you have to deal with, which is that once the date of 19 July 1948 is chosen in Article 6 for the conferment of deemed citizenship, then the argument was that you can't, by the exercise of an ordinary legislative power, reach that date of 19th of July 1948, because Bangladesh, 25 March 1971 and prior thereto, Bangladesh is a part of Pakistan. The area of Bangladesh now, specified territory, is a part of Pakistan. Albeit is Pakistan. Now, therefore, the argument is that you can't, in respect of a period covered when the specified territory was in fact a part of Pakistan, can't confer by deeming citizenship, by deeming an act of citizenship, because 6A also is deeming
confer
citizenship.
But not deemed.
You can't, yes, you can't, because you are making a deeming fiction. And that deeming fiction can't transgress the limitation which has been prescribed in Article 6. That's the argument.
The answer your lordships would get from the Constituent Assembly debates, which I have quoted, relevant part of only Article 11. Because the theme is...
One answer to that which we put to them was that Article 6 deals with the position as of the date of the adoption of the Constitution.
It
basically dealt with the historical context of partition. Article 6, the answer probably would be that Article 6 does not tie down the hands of a future parliament to decide to
the contingency is not contemplated
in Article 6. Article 6 can't be regarded as an exhaustive universe. That would be the simple answer, I think.
So your lordships would see Article 6. They say at the commencement of the Constitution. So, and they say very categorically while drafting the Constitution, while Article 11, that we may not be able to conceive of situations which might arise in future.
It's a declaration of citizenship for a group of people. Under the Constitution, that's all.
At that point of time, under those circumstances.
To accept their argument would mean that Article 11, the ambit would be to all countries other than Pakistan.
Yes.
Because that would be perhaps a very narrow reading of the power which is conferred by Parliament.
Another thing, apart from the fact that Article 11 starts with nothing in the foregoing provisions.
It's a non-obstante clause.
Initially, when it was introduced as a draft, it said, further provision governing citizenship, which was deleted consciously. But just give me 5-10 minutes. Can I please come to page 12, 14 of my written submission. 13 starts with drafting history of part 2, entire part 2, but we are more concerned with Article 11. Para 37. Does your lordships get it? 37. On 29th April 47, while moving clause 3, Sardar Patel requested that the following should be added to clause 3, thereby empowering the union. Further provision governing union citizenship may be made by laws of the nation. This was, my lord, the beginning of Article 11. This was conceived by Sardar Patel, my lords. My lord, thereafter, your lordships may, my lord, directly come to, my lord, it was referred to a committee. Please come to para 44. And the redrafted clause by the committee is, my lord, at para 44. It went before three different committees, my lord, this Article 11 issue. Thereafter, Sri B.N.
The
Rao,
constitution of the committee, it had Vardacharya,
my lord, all were eminent, my lord, please see.
Mr. Allah Krishna,
Kanayalal Munshi, K.N.
K.N.
Kaju,
Munshi and
Munshi
Dr.
and Dr. Ambedkar himself. We were fortunate to have, my lord, this constitution because of, my lord, people of this eminence and intellect. Then, my lord, what they suggested was every person born in India, in the union and subject to its jurisdiction, every person either of whose parents was at the time of such person's birth a citizen of union, and every person naturalized in the union shall be a citizen of union. Further provision regarding the acquisition and termination of union citizenship may be made by the law of the nation. Still further word remained, my lord. Thereafter, my lord, it was redrafted, and your lordships would find at page 44, para 3 only, my lord. Further provisions governing the acquisition and termination of union citizenship may be made by union law, that is parliamentary law. Then 45. Meanwhile, the Union and Provincial Constitution Committee at their joint sitting on June 5 appointed a subcommittee to consider in detail the effect of June 3 plan. My lord, that is Mountbatten plan. My lord, it's referred to as June 3 plan. The joint subcommittee met on June 8 and decided that the question of nationality and citizenship in the union should be re-examined by the ad hoc committee in light of the plan. In the report submitted by the Assembly on July 4, the Union Constitution Committee incorporated the citizenship provisions contained in the memorandum without any change, except that the word union was replaced by the word federation. In this connection, the committee quoted with approval the view of Calcutta Law Journal. It is not possible to define exhaustively the conditions of nationality, whether by birth or naturalization, by the Constitution. If certain conditions are laid down by the Constitution, difficulties may arise regarding the interpretation of future legislation which may appear to be contrary to or to depart in any way from them. The exact argument which is made. It would, in our opinion, therefore, be better to specify who would be citizens of Indian Union at the date when the Constitution comes into force, as in the Constitution of the Irish Free State, and leave the law regarding nationality to be provided for by the legislation by the Indian Union in accordance with accepted principles of private international law. But this gave birth to Article 11. It is now in the evolution process, my lord. My lord, please see para 48. When the draft was presented, I will not read, there were 140 amendments to the Constitution. Dr. Rajendra Prasad was pleased to say that you have it as a composite thing. Don't go one by one, but not relevant. Please come to para 50. Am I with you, Lord?
Yes, sir.
Para 50. The Constituent Assembly debates with regard to citizenship and especially Article 11. Lord, it was draft Article 6. So somewhere there would be a reference of Article 6, but that is present 11. Is illustrative and clearly points towards an overarching power being available to the Parliament. The following are the debates. Dr. Ambedkar, Mr. President, sir, except one other article in the draft Constitution, I do not think that any other article has given the drafting committee such a headache as this particular article. I do not know how many drafts were prepared and how many were destroyed as being inadequate to cover all the cases which it was thought necessary and desirable to cover. It is not the object of this particular article to lay down a permanent law of citizenship for this country. So it is very categorical. The business of laying down a permanent law of citizenship has been left to Parliament, and as members will see from the wording of Article 6, which is present earlier, my lord, avatar of 11. As I have moved, the entire matter regarding citizenship has been left to Parliament to determine by law that it may deem fit. The effect of Article 6 is this, that Parliament may not only take away citizenship from those who are declared to be citizens on the date of commencement of this constitution by the provisions of Article 5 and those that follow, but Parliament may make altogether a new law embodying new principles. They must not understand that the provisions that we are making for citizenship on the date of commencement of this constitution are going to be permanent or unalterable. All that we are doing is to decide ad hoc for the time. I don't think with respect there can be anything more clear than this. Then, my lord, next Dr. Rajendra Prasad, my lord, only highlighted part I may read. I would therefore suggest that amendments of this nature might also be left over to be dealt with by Parliament at a later stage, and we might confine ourselves to the limited question of laying down the qualification of citizenship on the day of Constitution came into force. As my lord, the Chief Justice, my lord, say. Then, my lords, your lordships may kindly come to page 19. There are other, my lord, honorable members saying the same thing, but page 19 is Lord Dr. Alladi Krishnan, Sri Alladi Krishna Swami Iyer, my lord, at page 19, my lords. The articles dealing with citizenship are therefore subject to any future nationality or citizenship law that may be passed by Parliament. Parliament has absolutely a free hand in enacting any law as to nationality or citizenship suited to the conditions of our country. It is not to be imagined that in a constitution dealing with several subjects, it is possible to deal with all the complicated problems that arise out of citizenship.